We're ready to go, Joe?
Yes.
Yes, we're ready.
Okay, this is the City of Green Bay Personnel Committee meeting on May 25th at 4:34 p.m. I will do the roll call. Alder Corpus Dax.
Here.
I'm sorry, I caught you with that potato chip.
That's all right.
Alder Johnson.
I saw his mouth move. I think he said
Okay.
here.
Alder Dorf.
Here.
And Alder Galvin is here. I'll entertain a motion on the agenda.
So moved.
And second, all those in favor say aye.
Aye.
Aye. That passes unanimously. I'll entertain a motion on the minutes.
So move to approve.
All right, all those in favor say aye.
Aye.
Aye, and that passes unanimously. On to regular business. Consideration with possible action on a request to fill the following replacement positions and all subsequent vacancies resulting from internal transfer. Administrative clerk, community and economic development. Does anybody have any questions for staff on this position?
To approve.
Second.
All those in favor say aye.
Aye.
Okay, on to number 2, consideration with possible action on the grievance filed by the Green Bay Firefighters Local 141 dated November 19th, 2020 regarding medical evaluations. The committee may convene in closed session pursuant to that, but before that, I have something I have to read before we even do something like that. So just give me a second. Pull it up. All right. All right, here's what I have. We're now on to item number 2, consideration with possible action on the grievance filed by Green Bay Firefighters Local 141 debate dated November 19th, 2020 regarding medical evaluations. This grievance is before the Personnel Committee meeting at this time upon the mutual agreement of the parties for extensions of time rather than at the meeting that was first available after filing. This is a quasi-judicial matter. It is the goal of the Personnel Committee to provide and conduct a hearing that is fair in form, appearance, and substance. To ensure that this hearing satisfies these goals, each member of the Personnel Committee please confirm the following by stating, I confirm. Number 1, I do not have an interest or conflict of interest in this matter. Alder Dorf.
I confirm.
Alder Corpus Dax.
I confirm.
Alder Johnson.
I confirm.
I have not received any communication from any person or party about this matter. Alder Dorf.
I confirm.
Alder Corpus Dax.
I confirm.
Alder Johnson.
I confirm.
And I confirm also to both of those items. A decision will be made based upon the labor agreement between the City of Green Bay and the Green Bay Area Firefighters Local 141 in effect as of the date of the event complained of. At this time, the following materials have been submitted into the record. Letter to Jeffrey A. Lacey with exhibits 1 through 7 dated April 22nd, 2021. Number 2, grievance exhibits, physical examination grievance. Number 3, Director Fald's Step 3 grievance response to the Personnel Committee regarding GBFFA grievance medical evaluation. Pursuant to Section 5.5.3 of the Labor Agreement, the committee may decide whether to hold a fact-finding hearing. No fact-finding hearing has been requested, but the union has requested 15 minutes to provide oral argument, and I'm advised that both parties are ready to proceed with this hearing tonight. Wishes the committee with respect to this request. And we need to take a vote to decide whether to hold a hearing or not.
I move that we hold a hearing. I made a motion. Is that what you wanted?
Yes, that's the motion. I need a second.
Second.
Okay, I have a second. All those in favor say aye.
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 Aye. Okay. So we will be holding a hearing. Each party will be allowed 15 minutes to present their position. The Personnel Committee will make findings of fact and conclusions of law based upon the testimony presented as well as the documents entered into the record. To ensure that this hearing proceeds in an orderly fashion, I will describe the process that will be followed. 1, the grievant will have 10 minutes to present its argument in support of the written submissions. 2, the city will have 10 minutes to present its argument in support of the written submissions. 3, the grievant will have 5 minutes for a closing statement. 4, the city will have 5 minutes for a closing statement. 5, throughout this process, the Personnel Committee members and the chair may ask questions of any speaker. Please answer the questions asked and do not engage in debate. 6, if anyone needs accommodations to hear or speak, please advise me now. Assistance will be provided if necessary. Does anyone need accommodations? Okay. And then 7, once arguments are concluded, the committee may go into closed session to deliberate, and a decision will be issued at the next committee meeting. All right, is the grievant ready to proceed?
Mr. Chair, we are ready to proceed. I believe, though, that the opening statements included an extension of time to 15 minutes from 10.
All righty.
I didn't hear that. I didn't understand that. What was said?
Yeah, let's see. Is my
Yes, sir. Go ahead.
is this
Go ahead.
better?
Yes.
Is this better?
Yeah.
Okay. I said that I understood that the extent that there was in the initial remarks an extension of time for the opening statements of both council or both parties from 10 minutes to 15.
So you're saying you believe you have 15 minutes to for an opening statement and presentation, and 5 minutes of a closing?
Yes, sir.
20 minutes?
Yes,
All
that
right.
is correct.
I guess I don't have an issue with that. Committee have an issue with that? Okay.
I also have a housekeeping matter. Do we have a shared screen feature available to us here?
You should. Joe, are you running this, or is someone else from your staff running this meeting?
I am. Attorney Hawks, are you able to share your screen right now?
I am.
Is it working?
Can you see that?
Yes.
Okay. So the
Yes.
Attorney Hawks, one thing as well, the city has the same document, and I guess we would ask the committee that either Attorney Hawks or ourselves, we can submit this Article 8 as a document for the committee to take under consideration.
I don't have a problem with that. Does anyone on the committee have a concern with that? No? Okay. All right. All right, Joe, are you able to set a timer? Not that I'm going to hold anyone to it to the exact second, but just so we keep things, rolling along and under control.
I would ask if she would be able to do that. Was there feedback on that? But
I was actually just going to suggest that I would be in charge of the timer.
All right.
thank you.
All right. So when Mr. Hawks, is that it? Are you ready to proceed?
I am.
All right, then you may begin when you're ready.
All right. The committee has received from the department a memorandum regarding the reasons why it should dismiss this grievance. And I'm here to respond to each of those arguments and explain why they are wrong. On the way to that discussion, we begin with a section called the background in the memo that you all have received. In that background, the city writes, the independent physician's determination that certain firefighters, only 3 of the 19 undergo stress testing prior to being cleared for duty, is what the association grieves. It is really important for me to emphasize that is not what the association grieves, and that the committee has been misled by that representation. What the association grieves is the city's and the department's refusal to bargain regarding the matters created by a significant change in the physical examination process involving firefighters. Along the way, you will hear me say at least once that firefighters, other than for the purpose of illegal drug testing, do not check their constitutional right of privacy at the door of the firehouse. You should know that this is not the case involving simply the question of the stress test or of the three involved in a subsequent testing process. It is a question about the duty of the city and the department to engage in bargaining with the union. Remarkably, this collective bargaining agreement contains a clause that incorporates the duty to bargain in good faith during the term of the contract as a contract provision itself. That means the city does not have only a statutory duty to bargain during the term of the contract, it also has a contractual duty to bargain during the term of the contract. The union came to the city to say, bargain with us, please, about these sorts of issues. And it's not just about the stress test. It is about a number of issues that are created by the stress test, as are indicated in a paragraph in the union's submission to you at the beginning, in anticipation of this hearing. So let me begin though quickly now to turn to the defenses that the city raises and address each of them in order. The first of those is that the contract requires the present dispute be resolved by declaratory ruling, not by grievance. The grievance is therefore improper. Wrong. Take a look at the shared screen. I have taken the time to highlight in yellow the language in this article of the contract that relates to changes in work rules, and highlight in green this language that relates to standard operating guidelines. So you will find that in green, you'll see the sentence, therefore the parties agree to the following process for recommending, negotiating, approving, and implementing SOGs so identified. And there in subpoint 3, the contract says, if there is a dispute over bargainability, then the party shall immediately seek a declaratory ruling from the Wisconsin Employment Relations Commission. That's fine. That relates only to SOGs. Now, SOGs are a very specific, well-defined, well-understood term in the operation of the fire department. Standard operating guidelines. This is a clause that applies to standard operating guidelines only. The issue that the union raises does not deal with the standard operating guideline. This doesn't appear. Everything in green in this article is irrelevant to the case. Everything in yellow is relevant to the case because we're dealing with a work rule. We're dealing, in essence, with an implicit, if not express, order of the department to comply with the medical examiner's prescriptions at the risk of losing their job. Now, notably, the medical examiner can't cost anybody the loss of their job. Only the chief can, and only on a review recommendation to the Police and Fire Commission. But the union understands that the chief isn't making this a voluntary option for firefighters to comply with those prescriptions. It is a mandatory prescription. If the chief was to say tonight to you, never mind, I don't care. If they don't have to follow the prescriptions of the medical director, it's up to them. This grievance is over. I doubt that the chief is going to volunteer that information to you tonight. Okay, so let's look at the changes to the work rules language. You have changes to work rules that affect wages, hours, and conditions of employment, which is the standard definition of mandatory subjects. Subject to mutual agreement before becoming effective. The employer agrees to negotiate changes in the existing work rules or the establishment of new work rules with the union. They shall be posted. All right, so does the present contract, according to, as argued by the city, require this dispute to be resolved by a declaratory ruling? Answer, no, clearly wrong. The contract specifies only that SOGs go to DR, a declaratory ruling process, according to the language of this contract.
Excuse me, Mr. Hawk?
Yes, sir.
Okay, so you're saying that this change in the medical physicals that the firefighters are receiving is a change of work rule and not a standard operating guideline.
Yeah, and actually, and this deals with the second defense of the employer that is, in our opinion, incorrect. It's not just the change, but also the establishment of a new work rule. So if you go down to the second sentence that's in yellow towards below the green, the employer agrees to negotiate changes in existing work rules or the establishment of new work rules with the union. They shall be posted. So, I mean, the answer to your question is this is a work rule, and in our submission initially to the committee, we included the dictionary definition of a rule and put it in context of work. And clearly when the chief says, I am ordering you to follow the prescription of the medical examiner at penalty of your job, it's a work rule. This is what you must do to be able to comply with the directions of the department. It is a work rule.
Okay, has the fire department given firefighters physicals in the past?
It has. It has indeed. What is different is never ordered them, no prior physical required them to undergo a stress test, or for that matter, a variety of other procedures in the current contract between the city and the medical and the physician provider, or Bellin, providing the service.
So in the
firefighter, just one more word on that.
I'm sorry.
No firefighter prior to this, the facts giving rise to this grievance, has ever been directed to engage in a stress test or other procedures at the risk of loss of their job. That is a function of the department and the chief's order, not of the medical director's order. That is the change that we're talking about.
So in the past, if a firefighter went in for their annual physical and who's ever giving the medical exam had a concern about their fitness for duty, how was that handled? To my client's memory, with regard to cardiac conditions, which is the area that I have inquired about. I have to limit my answer to that area. It has never happened before. We have had firefighters who have departed the service as a consequence of cardiac related issues, but they were never identified or reported to my client's memories as a consequence of the physical exams. But isn't that what the physical exam is there for, is to find out if they have any existing medical issues that could affect their ability to perform their job?
Yeah, the issue there is, where do you draw the line between which ones do and which ones don't?
Okay.
And in this case, drawing that line is very important. In the past, that line has been drawn by the employee's own treating physician. We've had cases in the department of just drawing a blank, aortic aneurysms in firefighters that have had the result of having them removed from service as a consequence of a duty disability. But they were identified and located by either the treating physician or by other circumstances, and then brought to the department's attention, not by physical exams that were conducted by the city. Wouldn't it have been or should have been anticipated that these physical exams may find issues? Yeah, I'm sure it is possible, but in other departments and in other circumstances, and on a point the union wants to negotiate with the department and the city, is do we involve the treating physicians, so with the employee's own physicians' assessment and evaluation of the condition before we put them out to pasture? And the answer to that question, clear from the union's point of view, is absolutely. No physician's opinion is infallible.
Okay, so moving on to work rules and standard operating guidelines. Can you point out to me where it shows somewhere in writing that the work rule, that these physical exams are listed under work rules as opposed to not being listed under standard operating guidelines?
To my client's understanding, there is no commonly used phrase or label of work rule in the operation of the fire department. So the only answer that we could provide this committee with in anticipation for this meeting today is the one that we have already provided, which is the dictionary definition of work rule, or dictionary definition, of work rule, which you have in the papers that we've submitted, which is a direction as conduct you must engage in, what is okay and what is not okay in terms of your conduct on the job.
So, This is what I'm thinking right now. What this whole thing boils down to is how this committee interprets whether this physical exam with the follow-up stress test falls under work rules or standard operating guidelines.
Yeah, and this is important to understand. I would disagree on a point. It's
Okay.
not whether or not what the medical director says about this issue. It's what the chief says about this issue. If the chief is saying to its employees that you must undergo these directed procedures by the medical examiner or the physician at risk of losing your job, then it is a work rule.
Okay. All right. I'll accept that that's the bargaining unit's interpretation. And I'm sure the city will argue their side of that then. All right. I'm sorry for the interruption, but I just want to make sure I'm understanding everything here. Thank you.
I appreciate the questions, actually. It makes understanding so much better. Then the second point of the defense is that the grievance is untimely. And in this argument, the city says it's untimely because the grievance was ripe at the time that the contract was let. And the union says absolutely not. This grievance was ripe only when it became clear of two things. One, failure to follow the guidance, the directive of the medical examiner would result in discipline. And two, the demand to bargain was denied. So the union made a specific demand to bargain preceding the collective bargaining and was told, no, we're not going to bargain about it. I mean, for Pete's sake, the whole principle of robust collective bargaining during the term is that if something comes up that's a problem, the employer and the union both can come up on either side, have a duty to bargain about it. What's unique about this case is that duty exists by virtue of the contract as well as the third point that the employer raises is that subject matter is not a mandatory subject of bargaining. Wrong again. We're talking about the impacts of the decision, not just a decision to require stress tests or the decision to undergo a physical exam. The union agrees that physical exam should be granted. The union agrees that in appropriate cases, a stress test should be directed. What they don't agree with is that the department's refusal to talk about the terms and the circumstances in which that stress test will be ordered. They have absolutely no issue with the physical exams. That is not an issue in this case whatsoever. The union agrees with that. They will agree in appropriate cases that stress tests should be ordered and that their members should comply. They're asking for, or they have proposed, a written specification of the criteria by which the stress test will be ordered. The department has refused to discuss that with the union.
Okay, if I can interrupt again.
Mm-hmm.
So the bargaining unit has no problem with a yearly physical.
Correct?
Okay, what they have a problem with is as part or resulting from that physical, the examiner, the person giving the physical, has a concern and wants to follow up with a stress test. That's what the bargaining unit has a problem with. Is that correct?
It's not just that, though. I've got to be careful about limiting the scope of the issue. And I cannot call up quickly the memo that was submitted to the committee. But in the second page, you'll see a paragraph that identifies each of several impact items that the union wants to negotiate with the department. And they range from who pays for what. If there's a stress test that's ordered by the department and the treating physician of the employee says no stress test is ordered, but the department's physician says a stress test is ordered, right now it's the department's position that the employee has, and the employee through his insurance has to pay the cost of the stress test. The union is saying, wait a minute, if his treating physician says that's unnecessary, why does he have to or she have to pay the cost of the stress test? The answer to that question, I'm only here to say, hey, the parties should sit down and talk about it and figure it out. And that's what the union is asking for as a remedy in this case. They would appreciate this committee saying to the department and the city, hey, go back, talk about this, guys, figure it out, and don't come back to us again. Get it solved. That is the remedy that we're asking this committee to endorse.
Okay. So, I'm sorry.
Time is up.
Okay, I'm sorry. I guess I didn't anticipate me asking questions during his presentation time. But I've taken up a lot of his time. So Mr. Hawks, until you're done with your presentation.
Good.
And I'll refrain questions.
I will do, and I'll be quick, and I want to encourage the committee to allow opposing counsel the same amount of time to respond. The subject matter of the union's bargain is not a mandatory subject of bargaining. I've already discussed that point to no work rule that has been changed. Well, I mean, this goes back to this definition of work rule issue. We think that a work rule is any rule of conduct, any order by the chief to conduct an employee to conduct themselves in a particular way as a work rule. There was no work rule that required employees to follow the orders of the physical exams in the past, of which we are aware. So there is a change. But the problem with it is a second point, and it's one that I made earlier. It's because we don't need to rely simply on a change of work rule. The contract specifies that the employer agrees, that's the city agrees, to negotiate changes in existing work rules or the establishment of new work rules. So here we have something that the employer is required for the first time in the history of the relationship between this union and the city. And it's a history, by the way, I have been a part of since about 1990. So I've got about 31 years of history of the department and the fire department in Green Bay in mind. So what we have here is a change, or either a change or the creation of a new work rule that has not previously existed, and the contract addresses that specifically. And even if the contract didn't, state law does. The parties have never negotiated the contents of medical examination as performed by the contracted medical provider because it's never been an issue. It's not a defense. There's never been an issue about the contents of the medical examination to be performed. I would add one more thing. I spoke to the chair. He's mentioned in the department's argument, John Crabb, who on the safety committee. I said, was there anything at all in the materials that you were provided or the discussions that occurred in the letting of this contract that alerted you to whether or not there was going to be a change, in the procedure, such that you could have raised the issue back at the time you were participating on it? And his testimony today, if we were taking witnesses, or at the time of hearing, if we have to go to hearing, will be no. There was no such information provided to him that alerted him to the scope and nature of these examinations and the orders of the department would be so radically different from what they had been in the past. The last offense of the city and the department is that the chief's obligation is regulatory and not restricted to the degree suggested by the union. We simply disagree with that. The state regulation directs the chief to take out of service firefighters with, quote, known, close quote, inability to perform the duties of a job. It does not open up the door to the chief to require firefighters to undergo physical examinations or any other kind of examination that permits the city and the government to basically investigate the very personal nature of their lives, their bodies, when there is not a known basis for being disqualified from service as a firefighter. And with that, I'll answer any other questions you might have.
Do any of the committee members have any questions for Attorney Hawks? And I can't see Brian. I don't know if Brian has any questions.
I'm good right now, Alder Galvin.
Okay. All right. Then this will be City of Green Bay's opportunity to lay out their case, and then each side will get roughly 5 minutes to make closing arguments. Director Falls, I guess you'll be leading the charge here.
Yeah, we'll have Attorney Jeff Lacey represent the city and present their argument.
All right, very good. Mr. Lacey, when you're ready.
Sure. Thank you, everybody. And I've got a timer running, so I'll try to keep control of my time as well, because, lawyers tend to talk too much. But anyway, I wanted to just address a couple of things that Attorney Hawks mentioned, which I think are part of the problem with this case. And actually, Joe, do you want to just leave that up? Let's just leave that up. if you can.
Yeah, I can share.
Or, I'm sorry, Tim, you had it up. Do you mind just throwing
I
that back
dropped it
up?
down. I'll put it back up.
Yeah, that'll be easier. Sorry, I forgot that wasn't you, Joe.
Does this work?
Yeah, that'll work.
We got it, Attorney Hawks.
Thank you.
Anyway, in a grievance situation, there's some sort of action, something that the city or the department in this case has actually done that causes the grievance. In this case, the city, the department hasn't done anything. It has simply continued to do what has always been done, which is have firefighters undergo annual physical examinations and presumably be certified or not certified, I suppose, by that independent third-party physician. The union frequently refers to this as the department's physician. That's just not an accurate description. This is, Bellin Health. It's a third independent actor. And they're the ones that make the determination as to whether a firefighter is, appropriate to service. According to Mr. Hawks, the purpose of the physical examination is essentially a completely pointless exercise. If the physician has no authority to determine that additional testing is warranted in a particular case for whatever medical determination that physician reaches that justifies additional testing, they have their standards. They're the medical experts, not myself, not Attorney Hawks, I don't know if there's any doctors on the personnel committee, but we leave that to the professionals. We leave that. The National Fire, the NFPA standards that were submitted by the union and are included in your packets, I believe, as Exhibit 6. Yeah. Where the structure of physical examinations are discussed in some detail, specifically says the purpose of those physical examinations is to identify conditions that may become disqualifiers. And there's a whole list of ailments that could disqualify an individual from service. And, included within that would be heart disease issues. So obviously no one can be excluded from service unless they have a known heart disease. To suggest otherwise just really doesn't make any sense. How that heart disease becomes known, however, includes the medical examination. That's the whole purpose of that examination. And on the one hand, the union says they don't object to the examination. They don't object to the physician performing the examination. They just simply object to the physician deciding that additional testing is required. But that's not a decision that the department makes. The conflation there that is what the union is relying on, that a physical examination process existed for, I think we both agree, as long as anybody can remember, certainly well preceding this round of examinations. And it's an independent physician that makes that determination. The stress testing that is the issue here is part of the RFP that was issued last year, which the department was involved in. Whether the question and what Mr. Hawks referenced, the union representative indicated they had no knowledge change in the work rule. Well, that's not the right question. He had access to the materials, the RFP materials, the question and answer addendum that was created as part of that process. All of these are in the materials that was submitted to the committee as well as the final award letter to Bellin Health, all of which contemplate the performance as directed by the physician of stress tests, as well as other types of tests that are programs and other sorts of determining whether an individual has a heart disease condition, as well as chest x-rays, as pulmonary functions are also exclusions from performance as a firefighter. All of that information was included in there. What they take issue with is how this particular physician has decided to perform that function. And that is just simply not something that's subject to the grievance procedure, not something that the city has even taken action. In fact, if the city starts meddling in how the physicians perform that function, I would expect that the firefighters should be concerned about what that means for their health and safety. A couple of other things that I want to point out. The union's letter that was submitted by Attorney Hawks suggests that this is some effort for the chief to be able to, quote, sack employees at will. And I just want to, that is absolutely ludicrous. There's no evidence of that. There's no evidence of anybody being disciplined, reprimanded, suspended, terminated, or even threatened with termination. In fact, the purpose is quite the opposite. Just as the NFPA standards, again, that were submitted to the committee by the union, those rely on that physical examination to identify conditions that could become disqualifiers so that they can be managed and the individual can continue to be certified. Having a known heart condition is not an automatic disqualifier. In fact, the regulation that you have very clearly says that that person could still be certified by the doctor. The whole point is to protect the health and safety of the firefighter themselves, but as well as every other firefighter that he has to serve alongside an individual, so that if they have some sort of heart or pulmonary, which seems to be the primary focus of those exclusions, that those things are identified and managed and treated early before they become catastrophic for the firefighter. On the contract itself, Mr. Hawks, I think, acknowledged essentially the end analysis here. There is no distinct definition of work rule versus standard operating guidelines. There's no indication of any work rule that relates specifically to physical examinations. There's no change to a work rule that relates to physical examinations. There's no additional work rule that's been created. All of this information, all of this process is longstanding. This RFP, again, refers to the NFPA standards. That the document submitted is 2018, so we know they are at least 3 years old, and that's, they go much, much further back than that. Stress testing is part of that system in numerous locations dealing with potential cardiac concerns and heart disease and so forth. So there's just absolutely nothing that has been changed, nothing that has been added, no additional requirement. And the effort to split hairs and determine that this structure for assuring that there's negotiations in an orderly fashion for changes to work rules and changes to standard operating guidelines, assuming changes modifies both of those, that's what the contract language says. So if we're going to split hairs and say this only refers to operating guidelines with respect to the specifics as to how the process is followed, then we're going to have to split the same hairs and say, well, it only refers to changes. And Mr. Hawks has acknowledged there is no change to any work rule, no change to any standard operating guidelines. Therefore, that's the end of the contract analysis. There's no duty to bargain.
Can I ask a question?
Yes. Oh, I'm sorry. I thought you were telling me 5 minutes was left, which is what my timer said.
No, but I'm really good at guessing times. My question is: so, is the grievance about giving a stress test to firefighters during their physical, or about who has to pay for the stress test, or is it both of those things?
Well, I'm glad you raised that, because that another item that Mr. Hawks stated, which is factually inaccurate. no firefighter is required to pay for the stress test that is ordered by the physician completing the medical certification examination. It's included in the RFP. It's included in the award. You can see the fee schedule is right in there. What the union suggested in its in the document that they submitted that was part of the demands with respect to bargaining the impact of this was that the city pay for any treat resulting from a diagnosis or whatever might be identified in the course of a physical examination. And of course, I would suggest that that's unreasonable, given, for example, if a firefighter has a physical examination, the physician's concerned about risk factors relative to cardiac function, orders a stress test, and let's say there is some heart disease that is identified, and maybe that requires a stent procedure. Now I'm talking about much about, but you get the idea. Well, that underlying condition that's now been identified and now being treated, the city doesn't pay for that, but they never would. No, personal health issue that arises would responsibility of the city. But the testing, the stress testing, if there's an EKG that's ordered, if there's a cancer screen that's part of that, all of that stuff is already paid for. But firefighters are not required to pay for the components of the tests that are part of the physical examination. That is just factually not accurate. As far as the again, the contract piece, I would submit to you either, and the way I would read this is the purpose of this contract language is if there are going to be changes to what exists already in terms of work rules or operating guidelines, that there's a procedure to follow. If that procedure includes bargaining, if it affects wages, hours, and conditions of employment, we're talking about impact bargaining, which requires there to be some change. That's the definition of impact bargaining. We bargain what happens when a rule is changed. So, for example, if an officer does miss time, we bargain the impact on their wages. That's a change. There has been no change. There is no change, and Attorney Hawks acknowledges that as he has to. But
that's not true.
Well, I didn't interrupt you when you were speaking, but that is what you said. The fact of the matter is there's no work rule that can be pointed to, nothing that can be changed. This contract language speaks specifically to a process involving changes of work rules and changes of standard operating guidelines. It then lays out sections that do not specifically refer to SOGs except in number 1. But number 3 just refers to generically a dispute over bargainability in terms of what's covered by that section, which, by the way, is titled work rules. So I think it's clear that the implication here is that if there is going to be a change to those things that are established, which logically makes sense, that in this context, because it's in the contract, we would have to go through this process. We dispute whether it's subject to negotiation at all, in part because it's not primarily or directly related to wages, hours, and conditions of employment, but also because it implicates a direct authority or a directive that's given to the chief in state regulation, which has to be adhered to. The chief, we can't negotiate away that obligation that the chief has as an individual. We also can't negotiate about what a physician can determine justifies further examination in a particular firefighter. We're not negotiate and dictate medical standards to an independent third-party physician, which is what Attorney Hawks and the union are requesting that we do. And I think on the point relative to the chief's authority, it is, as I mentioned, hyperbole initially to suggest that this is all about creating an opportunity to adversely affect firefighters' employment. It's just not supported by anything that's actually happened, and is patently unreasonable. What is reasonable though is these regulations, and that's a 97-page document that Tim submitted. When I saw that, I thought, oh my God, I'm not reading all this, but luckily we could skim through that. But it's all about maintaining the safety of the firefighter, about maintaining the safety of firefighters that go into emergency operations and rely on each other and depend on the other's ability to safely and effectively perform. And then also it is based on the concept of early identification of potential disqualifiers of a medical nature to keep the firefighters on the job. Because everybody, you don't have to be a doctor to understand that the sooner that you identify and treat and manage conditions, the better your chances are of keeping it from becoming that disqualifying condition.
I have another question.
Yeah, thank you.
Okay. So initially, when I was reading through this and what you were saying, it was about whether the doctor can order a stress test or not. But then it became bigger because now there are actually 4 different things that are being asked for, right? It's not, it got really way bigger than the first grievance memo where it was just about the stress test. Didn't it? Are you defending all of those areas?
Yeah, I guess what I would say is that's been part of the difficulty with this, and part of the reason why we said this is why we should be going to the commission for declaratory ruling, because we've been trying to nail the union down on exactly what it is they want. Yeah. Because again, the physical examination, what we agreed to, and this is what I heard, and Attorney Hawks can dispute this if he meant something else, but what I heard is the union does not take issue with the physical examinations. The union does not take issue with the fact that the physical examination structure protocol includes stress testing as a potential. It's written right into all the documents. What it takes issue with is the fact that somebody actually was required to go through that process. And it happens to be that it involves stress testing, but the physical examination protocol involves a whole host of other potential, additional tests that could be ordered. I pointed out a couple of them because they're the ones written in either specifically into the additional questions that were part of the RFP. A host of additional tests that are available going through the NFPA standards, all intended to identify, based on what a physician's initial examination concludes are appropriate additional testing, to identify whether or not there is a condition that is one of the potentially disqualifying conditions. Again, that's the whole purpose of the examination. It says it right in the standards. The purpose of the examination is to identify potential health conditions. I'm paraphrasing there, but so to answer your question, I'm not entirely sure what, and that's the problem, because there is no work rule that's been changed. We've been saying, what is this work rule? What are you talking about? What's been changed? There is no work rule that's been changed. And it's the physician who makes the decision. Certainly we're not to the position where the fire department and the union leadership are going to dictate to the physician how they determine whether appropriate whether risk factors exist such that a stress test is justified before that physician in his or her medical judgment will certify a firefighter. But beyond that, I don't know what it is they're asking for, other than to supplant the independent doctor when they don't like the determination that doctor reaches by requiring to or deference to the firefighter's treating physician, if in fact there is one, which of course is another issue. Barb.
Okay, so there were always physicals
Yes.
required, right?
Let me just,
Or is it-
can I
is-
just pop in and say that both parties have used about the same amount? It's up to the council or to the committee on whether they want to continue asking questions. That's entirely permissible. But I just wanted to let you guys know that both parties have used about the same amount of time now.
Barb, before you ask your question, Mr. Lacy, do you have any other comments you wanted to make, or are you done pretty much and you can start taking questions?
Yeah, I'm comfortable taking questions from here on out. Thank you.
Oh, okay, I'm sorry. Go ahead, Barb.
Just so there are physicals required. Is that correct?
As far back as anybody who's been involved in this can identify, yes.
But there was never ever a stress test before this year. Is that what the concern is?
Well,
I mean, I'm not
know.
saying stress tests are good or bad. I'm just
Sure.
saying, is that why this popped up? Because this complaint looks bigger than just stress tests. The 4 things that they're asking for, it's very large, not just
Right.
about stress tests. So are we talking about way more than stress tests?
Well, I don't know if stress tests have been required by the physician conducting the physical examinations in the past, but stress testing as a component of the physical examination process, when indicated by the physician, it's part of the standards that are what the requests for proposals most recently in 2019 and 2020 incorporated. That's what it's been around for, preceding that as well. Stress testing is part of that protocol when the physician determines that it is appropriate. Based on
in my mind, something has happened to create a lot of anxiety, because I'm reading that a process has to be designed to resolve conflicts between the city's physician and the member's treating physician, and that the department will apply the standards regarding fitness for duty, and that there's prescribed treatment, written documentation is required. There's a lot of anxiety I see being raised in these demands. And I'm just trying to figure out, is the inception of all of this concern and fear because stress tests were suddenly required?
And
I mean, whoever can answer that question.
Well, and if I could just follow this up, Barb, and join my question with yours.
Sure.
And this would be for Attorney Hawks, because I think he's the one that's going to answer your question here. Okay. If any part of this physical, do they do an eye exam as part of the physical? Let's say they do. If as part of that eye exam, the doctor had a concern and wanted a follow-up eye exam, would the bargaining unit have the same concern about that as they do about this stress test?
Monocular vision is a basis for, under the NFPA standards, for elimination from service. So yes.
Okay.
If there was a debate between physicians as to whether or not monocular vision existed or did not, the union would be interested in negotiating a process by which the physician's disagreement could be resolved. I have
So
done
this
that.
is all a big precedent-setting thing. It's way bigger than stress tests. It's for us, if we come back with some kind of ruling, it sets a precedent for any kind of physical exam. That's what it looks like to me when I look at the final memo. But
again, go ahead, Mr. Lacy.
I was just going to briefly say that, perhaps most succinctly what the union wants is a second opinion, basically the firefighter's own physician perhaps, but that the independent physician that we and the city council approved hiring and that we pay to do these physical examinations would not be the end all be all decision maker, that we would be forced then to enter into some kind of process where the physicians would reach agreement. And that might be something that makes sense. I don't necessarily think it does, but there's no basis to require the department to enter into discussing and negotiating a structure like that. It's never been the case. There's been nothing that's changed about this other than who the doctor is that's performing these, but that doesn't change a work rule. That just changes, what the Bellin Health organization puts forward as the physician doing the work. In fact, when this started, the RFP process, it was in response to concerns from union members that they wanted it to be done, the examinations to be done by a physician, not a physician assistant, not a nurse practitioner. And the department was responsive to that. So, Chief, I don't know if you have anything you want to add relative to, what your experience with the examinations has been. And I'm sorry, I shouldn't just assume that from the committee.
Is that part of the process? I don't think we are calling witnesses today.
Right, no.
If we did, I would have had the union witness.
Exactly, Mr. Hawks. And I guess I would say I can somewhat understand the bargaining unit's concern. Years ago, we had officers that were on disability from a duty-related injury, and they were showing back up at work because their personal doctor said they were fit for duty. Well, then we found these officers could not perform their duties, and these doctors were saying they were fit for duty, not knowing what an officer needed to be fit for duty. And that was when the city started getting their own doctor involved to have the officers exam before they were declared fit for duty or not fit for duty. So I can certainly see where there might be some concern or about the doctor that has been hired by the city to conduct these physicals. What if I go in and the city doctor says I need to get a stress test and my own doctor says you don't, based on my examination. And I think that's some of the concern that the bargaining unit has here. But before that rabbit hole, and that's a pretty big rabbit hole, I still think the substance of this whole thing is does it go to our decision is this something that should be bargained, or is this something that should be a declaratory ruling? I don't know if we necessarily need to get into the meat of stress test versus no stress test and what are the bits and pieces that they want to go along with it and all that other stuff. If I'm incorrect, someone please explain to me how what we should be looking at.
I would like to respond to one of Lacey's remarks and also pick up the rebuttal.
Hang on just one second, Mr. Hawks. Does anyone have any other questions before Mr. Hawks proceeds?
Well, I'd like your question to get answered that you just asked first. Why can't, I think it should get answered.
Okay.
By the attorney or by Joe, somebody needs to answer that. Are we talking about the things they're asking for? Or are we just saying, is this declaratory or does it have to be bargained? What are we here for? I need to understand that.
I will take the floor then to answer that question from the union's point of view.
All right, Mr. Hawks.
I'm sure it will be contested. But from the union's point of view, the only way you get to a DR pursuant to the contract is if you have a change of the standard operating regulation, an SOG. And that's what the contract says. It's just plain, it's unambiguous, it's what the contract says. I have confirmed a prior knowledge or a prior understanding of the law on this point of whether or not you could get a DR from the WRC outside of the contract. And the answer from the WRC is no, probably not. There's a discretionary, under Chapter 227, there's a discretionary process to get a declaratory ruling from an agency. WRC's position is unless it's a matter of statewide concern, we're not going to grant the petition. So, we don't get there. You don't get to a DR. You don't get there under the contract. We will resist it. And you're not going to get there under the current reading of Chapter 227, which is the chapter dealing with administrative procedure in Wisconsin. So, no, we don't get to a DR. We get to an arbitration. Ultimately, even the WRC, I predict, will say no issues. arbitrations or procedural issues have to be decided by the arbitrator because that's what the parties have agreed. So, that's the answer. That's my answer on behalf of the union to your question, Alderdorf.
And I would say, first of all, I think there's a distinction between creating an obligation on the commission to engage in declaratory ruling activity by virtue of the contract, which I would agree the commission refused to do that, versus saying if we have a disagreement over bargainability, which is what declaratory rulings do all the time, determine whether something is in fact subject to bargainability, which would be, is it permissive, is it mandatory, or is it prohibited? That's what a declaratory ruling is all the time. In terms of, what this committee is looking at, I think, number one, is there a distinction between work rule and SOG? If there is, nobody knows what it is. Because we have a dictionary definition is not a contractual definition. There's no knowledge of what that distinction is. And we have a procedure that refers to SOGs in the procedure only as to number one. The rest it's not, plain and unambiguous that only applies to SOGs and not work rules. But we also have clear language that says none of this means anything if there isn't a change to an existing work rule or to an existing SOG. And no such work rule or SOG exists that has been changed. In fact, again, back to my original point, no action has even been taken by the city, the department in this case. It's been entirely the physician who conducts the medical certifications and does that pursuant to a grant, an award after an RFP to conduct NFPA 1582 compliant examinations, not personal doctor, not family physician, not personal cardiologist. Not to take anything away from those physicians, fantastic professionals, but the NFPA compliant examinations are a different thing. They're a specific thing, and that's what we have performed.
In my rebuttal arguments, I've identified 3 points I want to make. Is it appropriate for me to proceed to rebut? The first of one of those deals directly with the last remarks.
Well, and I know you're trying to keep a thing on here, but if everyone's all done with their questions, then I think we can go into the rebuttals. And then Mr. Hawks, if no one has any questions, okay, Mr. Hawkson, you may proceed.
The very first one goes to this contention by Attorney Lacey that I have admitted that there was not a change. I want to rebut that most directly as possible. There were nearly 20 firefighters required to undergo stress tests in 2020. In no other period of time, anyone who I have interviewed to prepare for this grievance can remember any other firefighter being directed to undergo a stress test. That is a change. To Alder Dorf's point, imagine being 48 years old, slightly overweight, with a little bit elevated blood pressure, and with 4 kids, 2 in college, and being told that you have to undergo a stress test that may result in your termination of employment. That's a change. That's what this union is talking about. And the argument that there's been no change is simply absurd. Simply absurd. I have pulled up the exhibit or the memo that we filed with this committee. And if I can get shared screen opportunity again, Joe. I got it. So what I did was cut and paste one paragraph of that memo I submitted to the committee. Again, going to Alder Dorf's comments that this is a bigger issue than just stress tests. I couldn't agree more with that observation. It is a bigger issue. So in the memo we wrote, the department fails to distinguish between effects or impact bargaining and decision bargaining. Now, that may sound like labor law jargon. It is, but it's jargon with a meaning. If, for example, a school district decided to have of 20, that is a decision which is a permissive subject of bargaining. If the union turns around and says for every student over 20, you need to pay the teacher X dollars more. That is an impact proposal. That proposal is a mandatory subject of bargaining. So in this case, the union has said the department, the contract requires you to bargain with us. We want to bargain not just about the decision, but also about the impacts or effects of that decision. There's a whole section in El Curry how arbitration works. So there's a treatise that deals with this. In there, I wrote on behalf of my client, the union doesn't challenge a decision to require stress tests. Instead, it requires bargaining over the impacts, specification of the criteria by which the decision to require a stress test may be made. That's important. Right now, there are 20 firefighters who were required to undergo stress tests, and none of them could say why they were obligated to do so while others were not. These are the people that are subject to the fear about possibly losing their employment, and why they think it's important to know why they, as opposed to others, were not required to undergo stress tests. Secondly, the specification of the results of the test by which disqualification from employment will be made. So exactly what is it in the stress test that results in a firing as opposed to no firing? That's not unreasonable. That's not unreasonable. That's an impact of the decision to require stress tests. Development of accommodations for total disability. Well, wait a minute. Now we've got a disability. We have to talk about the Americans with Disabilities Act and whether or not there's an accommodation that may be made. In the past, the department has made, and believe me, the union has been tremendously appreciative of the relationship it has had with the department over the years on these sorts of issues. I can say in 31 years, I cannot recall a grievance arbitration. Now think about that. This is a sophisticated relationship historically. The results of tests by which development of accommodations to cover newly covered disability, covering the cost of lost time, agreeing to the light duty workday. What do you need for time? If you need time or you're not going to be in full service, can we talk about the light duty workday and continue your employment for the time where we're trying to figure out whether or not we can get you back into service? Agreeing to and express incorporation of standards established by the NFPA. So there's been frequent references to the NFPA standards. They have these standards written into them. That's 175 pages. It's not accidental. And that's the Chiefs Association that's largely responsible for the development of the NFPA standards. But most importantly, the department refuses to negotiate a fair, sensible procedure to resolve the dispute between an employee's treating cardiologist and the department's physician. And it doesn't have to be a cardiologist, it could be an orthopedic surgeon. If we have joint injuries or repaired joints, this whole issue can turn on that. I have negotiated agreements and collective bargaining agreements in the past where the union and the employer agree that the physicians will pick the tiebreaker. And then all parties will live with the tiebreaker's decision, whatever it may be. So it's possible, it's wise, in my opinion. That's all this union is requesting to do in this case. It encourages everybody to slow down, go back to the bargaining table, and figure out the answers as opposed to picking a fight. That's it.
Okay, and Mr. Lacy?
Yeah, just a couple of quick points. First of all, none of the things that Mr. Hawks just went through are items that have anything to do with what the union has said is the work rule relative to the physical examination. None of that has changed. A firefighter could have been disqualified for medical purposes in the past, And all of these things would have been appropriate, potentially, items to have in terms of a procedure and so forth, many of which we would have to follow anyway. The city has to follow the ADA. So we have a legal structure that exists. This is not something that they're creating and coming up with. But specifications of the test, again, we don't get to negotiate and dictate to a physician how it is they're going to make the determination relative to an individual's physical fitness when they are told and they agree, and this is the whole process that was taken to select the individual or the organization doing it, that the tests are pursuant to or compliant with the NFPA standards that Attorney Hawks just referenced again. That's the key. Of course it has to be compliant with that. That's the whole purpose. And to suggest that our position that there's been no change is absurd. It just reminds me of the old adage: when you have the facts, pound the facts; when you have the law, pound the law; when you have neither, pound the table. That's basically what that argument is. Directed by whom? It's directed by the doctor. Nobody in the department directed these specific people, handpicked these people and targeted them for additional testing. There's no evidence of that and no basis to suggest that. That's why we have independent physicians conduct these certifications, examinations. But, and then lastly, I would just say to the passionate, and I always respect Tim, he's a passionate guy, but to the passionate argument that, firefighters potentially losing their jobs over there, I would say, if you're a firefighter, how do you feel if you walk into a fire and you have a heart attack? Because nobody has required that this physical examination process be robust, that it be targeted as the NFP standards set forth to identify it, potentially in the earliest stages, since we do these annually, whether there is some health concern that ultimately could become a disqualifier. I would rather be the firefighter who finds out early, gets the treatment and whatever is necessary to manage that, rather than find out when it's too late, or be the partner of a firefighter who finds out too late, and I'm going to try to drag them out of the building as well. That's what this is about. It's about safety, and it's not about trying to sack firefighters. It's about maintaining and assuring the safety, something that this department, in the support of the council, has done quite a bit of in terms of programs, equipment that has been purchased for the department to help improve the health and safety of the firefighters. That's all I had.
Okay. I thank both the city and the bargaining unit for their presentation. And if no more questions, I'll entertain a motion, whether you want to go into closed session or not. You're muted.
I move that we go into closed session.
Second.
I have a second. All those in favor say aye.
Aye.
Aye. We'll be going into closed session. I'll have Barb read the verbiage, but then before we do, I just want to ask a question of Attorney Chavez. Go ahead.
Before we go in or before I read it?
Right, before we go in, yeah.
Okay. The committee may convene in closed session pursuant to section 19.851A Wisconsin statutes for purposes of deliberating concerning a case which was the subject of any judicial or quasi-judicial trial or hearing before that governmental body. The committee will thereafter reconvene in open session pursuant to section 19.852 will take action on items discussed in closed session, if appropriate, and to consider the remainder of the agenda.
All right, thank you. And Attorney Chavez?
Yes, sir.
Since this committee is going to be giving out its decision at the next personnel meeting, is there any reason that anyone that's involved with either side here has to stay, or could they log out and enjoy some of this weather we have right now?
They do not need to stay.
All right. I mean, if Attorney Hawks, if you and your people want to stay, I mean, certainly, same thing for anyone from the city, but like I said, we're not going to be rendering a decision until next week. And so if you guys want to head out and enjoy this weather while we have it, by all means.
And take off this tie.
Yes, start with that and then go down from there.
Yeah. Thank you. No, we'll depart. Thank you for the.
Thank you for your time, everybody. Appreciate it.
Thank you.
Passes unanimously. We're back in open session. On to item number 3, consideration with possible action to have staff study the need for more staff for the city attorney's office.
Is there any motion taken on the second one?
No.
I don't think so.
Okay.
We're going to make our decision at the next
week.
Okay, sounds good.
Yes, this matter has just been taken under advisement. I mean, that's all that's happened right now.
Okay, then we'll just.
I guess should I report any motion, or what should we report in the minutes?
It would be appropriate to make a motion to hold until this meeting.
Oh, okay.
I move to hold till the next meeting.
Second.
All those in favor say aye.
Aye.
Aye, and that passes unanimously that we're going to hold it until the next meeting. On to number 3, consideration with possible action to have staff study the need for more staff for the city attorney's office. Staff.
That's me again.
Okay.
So we have been looking at the need for additional staff, and I can provide you guys with an update as far as what we need. I think that the better approach for that, though, might be as we get closer to the budget. Instead, as far as what addressing some of the temporary needs, I went through and identified the items that we need to address on a pretty quick basis that would allow the department to start focusing on some of those things that have been bottlenecking. And I think that, so we, as I reported before, we explored looking at outside counsel. We looked at hiring somebody on a temporary basis. We looked at hiring somebody who's retired and has lots of experience on a temporary basis. I was only able to speak to one person who's potentially interested, who is formerly retired. And although he seemed like a good fit at the outset, there were some limitations based on the fact that he is retired. And then some of the things that he's just not doing anymore, such as litigation, and we do need some litigation help. Hiring a new employee at this stage would not be a means to clear the backlog, simply because it will take a while to get them up to speed. So if we're looking at some temporary or a quick way to get things moving forward from the law department, the solution is really to hire out or to farm out some of our caseload. So I've identified a number of items that I think are appropriate to farm out, which will free up our legislative attorney to focus on some of the litigation. So I can go over what I've identified with you, or I can just give you guys a number. What would you prefer?
I'm okay with a number. Rest of the committee?
Fine with the number.
Yeah.
Okay. I think the number's appropriate, because I think we'd need to defer to your expertise on, what's appropriate to farm out versus what you do internally.
Okay. So to farm out all of the items that I think will clear that to allow the legislative attorney get to those things, we're looking at about $45,000. I think that if we even took 30,000, I think that we would make a pretty good, dent. But I would say that 46 or 45 is really the number that would make the most dent for the city.
And Vanessa, with that said, and I want to make sure I understood you, this is short term, but we are still working towards adding staff or seeing if we can or should add staff on a permanent basis, more in junction with the new budget coming up, correct?
Correct. Okay. We are looking at all options that are available to us, whether it's we realize that ARPA is going to be an ongoing issue for us. We're exploring whether or not there's opportunity to fund at least part of the position to take care of that. We're looking at what kind of needs we have as far as, is this person just going to be clearing some backlog, or is it somebody who's going to actually be taking on new additional responsibilities? We're also looking at potentially filling some gaps in our department. We have one employee who's going to be going on maternity leave soon, so we're looking at ways that we can make sure that we don't go further into a workload hole than we already are. So we are trying to be as proactive as possible. This is just this is the way we see of making this backlog workable until we get there.
Okay. Go ahead, Alder Dorf.
So then we would just need to put a proposal into finance. I know our contingency, we still, because it's the next meeting, still have 150,000 in our contingency. So it seems like 45,000 would be a reasonable number at this point for us to commit.
All right. And did we have money left over from last year yet?
That goes away, sir.
Yeah, I think it goes back into the general fund. We should look at using contingency, I think, but we should not talk about it in this meeting. This is personnel.
Right. Okay.
We got to talk about it's not on the agenda for finance, so we have to put it on.
Okay. Well, I like the idea of taking care of some short-term needs that need to be done now as we look forward to the future, adding on the staff that's going to be necessary, so we don't end up having to. Hold on, my dog's eating my mouse cord. So that we don't have to be hiring out all the time. And I know there will be times we have to, but when I heard recently that we had one open records request that took 200 person hours to fulfill, and we've been getting inundated with a lot of requests that are sucking up a lot of our staff's time. And I don't anticipate that stopping anytime in the near future. We need to do what's going to be best so we can get the most out of our employees. Alder Johnson.
Thank you, Alder Galvin. And I think if we do forward this on to finance with a recommendation, I do think it would be appropriate there to provide a list of what we're trying to clean up in terms of a backlog. The one question, though, Attorney Chavez, that I would have for you is thinking about some of the thing hogs this past year. I think a lot of it are directly related to election, whether it's items that we initiated or like open records requests that we've had to respond to. Those to me feel like kind of one-time things. Do you envision, and when we start talking about permanent additions into the future, I guess what I'm really trying to wrap my arm around is the backlog being driven and created by things that have happened this past year that we don't anticipate to repeat?
Yes and no. So the extent of the backlog is really high, but what we've also discovered is that there are a lot of things that law department just isn't capable of handling. Like we just don't have enough people to be able to touch a number of things that we probably need to. So for example, we should be doing trainings on a regular basis to reduce the potential for liability. And we're not able to get to those types of things. We should be doing, we should be attending or providing more coverage at council, or not council meetings, various committee meetings to make sure that all of the proceedings have legal counsel available to them. We're not able to with their current staffing levels. So we're picking the ones that have the either items that require an attorney to be present or have the potential for the biggest areas of concern. We just have a ton of things that are happening that we should be doing and aren't. So that's why I say we're looking at this position as, is it really going to be something that's going to fill an existing void, or is it something that's going to be able to, or is it just really just like picking up the slack where it exists?
I would have to concur with that from what I've seen going on in the attorney's office, both when I was an employee of the city and with some of the requests I've had in there over the last 5 years. They're just not, they just don't have the staff to get things done in a timely fashion. And then, this year, it was an anomaly, but the backlog was there even prior to this. So I'd like, go ahead.
I'd like to make a motion that we refer this to finance for the June 22nd meeting of finance.
And that Attorney Chavez continue to work on coming up with a firm number of what she thinks the city attorney's office needs.
The ones that have the plastic wrap on.
And I'll second that, but I'd like to maybe just add some caveats to it if I could. And these don't have to be documented. It's more so just if Attorney Chavez could consider this when it comes back. It doesn't need to be part of the formal motion. One, again, is an actual listing of those things that we'd be looking to outsource. And you mentioned things that right now that we're not maybe giving full attention to that require or should have full attention. If we could maybe just list some of those items, I think that would be helpful as well to understand where we're sort of missing the boat a little bit. And then the other thing that I still would like to see is what do comparable cities look like in terms of, how much they're allocating towards legal fees. And I know it's never an apples to apples comparison, but I think it would be useful for us to understand, hey, other cities of approximately this many people have a legal budget that's this much, whether it's in-house, outsourced. I understand every community might respond to that a little bit differently, but I think that would be useful information for us when determining what's necessary there.
Okay.
Is there a second to my motion?
Yeah, that was a second. And
that was a second. Okay.
yeah, but I said I just wanted to add those couple extra things, not necessarily part of the motion, no.
All right.
I do second it.
All those in favor say aye.
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 And that passes unanimously. On to informational. Does anyone have any questions for number 1, the report of routine personal actions for regular employees?
Motion to receive and place on file.
Second.
All those in favor say aye.
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 Aye. And we don't meet again till June 22nd?
Right.
Holy cow. Okay. All those in favor, entertain what?
We don't meet again until June 22nd.
That's exactly.
So
Right.
the grievance issue that we just had
June
won't come back
22nd.
until then?
June 22nd.
So
Okay.
don't throw away your notes.
And I did notify the parties of that.
Okay.
All right. I'll entertain a
To adjourn.
motion. Yep, there we go.
Veronica.
Second.
Okay, all those in favor say aye.
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 Aye. All right.
How much time do we have?
5 minutes or more?
5
Do you need
minutes.
10? You want 10? What do you want, Alders?
Should we do 10?
7.
Yeah.
10.
It's 6:58. We will convene at 7:07. 9 minutes. Go.
Go.
Right now. Go.